Second provision problem that might happen, if you give notice to both the speaker and the deputy speaker, then there'll be nobody left.
Article 180, some other person will be appointed.
Can't be Malad under the 10th schedule.
Now, 180,
Having been repealed, Malads, 1/3 can still topple the government, and a notice under 179 will freeze the hands of the tribunal. Secondly, that 2 days notice. That's also contrary to Kyoto. So a judgment of a court actually led to the toppling of the government. Otherwise, it would not have happened.
It was based entirely on Navam Arabia.
No.
That you cannot. No. We were all there. And nowadays there is video recording also. Based on the fact that you can, otherwise the disqualification can't be stopped. The idea, what is the foundation of the whole case? The foundation of the whole case is that I have given a notice to the speaker. The speaker.
So Kyoto assumes that there can be no interdiction by the court till the speaker decides the matter. If you interpret 179 in the manner that Navam Arabia interprets, you then automatically say that there is a stay as far as the speaker dealing with disqualification petitions is concerned.
yes.
It's the other problem.
Yes.
So you don't interpret one constitutional provision to derogate power of a constitutional authority vested in another constitution. So you have to actually provide a balance. And the only balance that can be provided is that he is not disqualified till such time as the resolution is moved and voted. That's the only balance.
Yes.
That's another point that I wish to make for your lordship. The other thing, Malad, that I am somewhat concerned about is that a 14-day notice is constitutionally provided. Then a 7-day period during the assembly. Now, Malad, supposing the 7th in the session for 3 days or 4 days. And if you, Malad, then of the judgment of Navam Arabia, if you interpret notice provision in a manner, it is automatically for a year or 2 years. So what's going to happen?
All.
The session will not be for 7 days, so it will continue till the next. And so, Malad, why would your lordships interpret these constitutional provisions in this fashion? By attributing or assuming that the speaker will function in a manner when he's functioning as under a schedule. The second provision problem that might happen, if you give notice to both the speaker and the deputy speaker, then there'll be nobody left.
Article 180, some other person will be appointed.
Can't be Malad under the 10th schedule.
Now, 180 is, no, not 10th schedule.
I'm talking about the 10th schedule, Malad. Then what will happen? Because if the judgment is right, then there'll be nobody. But both, there'll be a notice for both. That also your lordship should not allow. The other issue with us is that now we are trying to balance between the removal of the speaker and the functioning under the 10th schedule. Well, let's take a case of small, most of these things happen in small states. You have a 5-member party, 2 of them move on to the other party, give a notice to the speaker, government falls, and those matters are not decided. So it has disastrous consequences. Then look at it from another standpoint. Look at it from the point of view of paragraph 3 of the 10th schedule, that's been repealed. What if paragraph 3 says you must have at least 1/3? At least 1/3. That's repealed. Why? Because they thought that was also being misused. Now, if you interpret 179C in this fashion, that 1/3 comes back to the back door. Because 1/3 in an assembly can topple the government. So paragraph 3 having been repealed, Malaz, 1/3 can still topple the government, and a notice under 179 will freeze the hands of the tribunal. So in a sense, you are bringing back through this interpretation a small minority in an assembly who then, Malaz, for reasons that we all know, go to the other side and Malaz makes the government fall. And then you say, no, but the speaker may have, maybe we should not have allowed the speaker this time because he may. Ultimately, Malaz, if the speaker is removed, let's put it this way, if the speaker is removed, he's only removed from one office. There'll be another person who will be a speaker. But if an elected government, Malaz, is actually toppled by this subterfuge, Malaz, the harm to the polity is much greater. Look at it from that point of view. Because if supposing Malaz is speaker and it is found that actually these persons were disqualified, should be disqualified and are disqualified, speaker can't come back, get back to the office. But when people who are disqualified, they are not disqualified, they can come back to the office. Judicial review is available. So from any standpoint, you can't balance the two. You're talking about one man moving a notice, sway one person, and you're talking about the whole polity and the whole 10th schedule being misused. Proper elected. There is no way that you can balance between the two. The only balance is that you cannot allow elected governments to be toppled.
Yes.
The message of the governor. In these circumstances, this honorable court considered the legality of the decision of the governor to prepone the assembly session. It was held that the governor's decision to prepone the assembly session was unlawful, as he had acted without the aid and advice of the Council of Ministers. Well, essentially what it said was that the discretion of the governor is enunciated in specific articles of the Constitution. Right? For example, Article 200. You send a bill, Malas, to the governor for his signature. He thinks that the bill requires further consideration. He can send it back. He can keep the bill and keep it pending for this consideration of the president. He can send the bill to the president. These are powers granted by the Constitution by the governor to act in his discretion. For example, Malas, under 371, 5th, 6th, 7th schedule, Malas, your lordship knows, not 7th, 5th and 6th schedules, governors have discretionary powers. So the court said that this discretion is enunciated by specific provisions of the Constitution. That order of this court on 27th of June is squarely, Malas, in issue. Because that led to the toppling of the government. Extended the response to 12th of July. So it automatically stayed the disqualification proceeding. That was the ground taken, that because of Namam Reva, taken, just show that you cannot proceed, you cannot proceed. And secondly, that 2 days notice, that's also contrary to Kyoto. So a judgment of a court actually led to the toppling of the government. Otherwise, it would not have happened. And that your lordship still have to decide. Let's show to one. Page 1. Then what happened is, Millers, then we moved Millers on the 29th of June, because Millers, the government, the next day, Millers, they would have been sworn. On 29th of June, when we moved the court and said, look, don't allow this to happen, the court said everything that happens from now on will be subject to the outcome of the petition. Then that order, Millers, also is there. So all consequential acts after 29th of June. 29th of June, what happened? 29th of June, Millers, be moved. Yes. Now, Millers, if your lordship looks at this petition.
So the effect of the order of 29th of June
yes,
was that those disqualification petition would participate in the floor test
Yes.
on the 30th.
Yes.
That's
And
why the
everything will be subject to the outcome.
And the government then resigned.
Yes. That's how they got toppled. Man.
But
there was no floor test.
One thing your worship should know.
But there was no floor test.
There was no floor test, my
No,
lord.
no, there was naturally because he resigned.
He resigned.
It was only 4th of June. July.
Vote is 4th of June.
July.
Conjunct of floor test.
One second,
The
one.
Chief Minister signed the same.
That's right. So fine, that's fine. Why would he? Why would he?
No, the chief minister resigned because once those persons against whom
Foregone-
there were
It's a foregone
disqualified
conclusion.
were permitted to participate in the
Yes.
floor test, the result was going to be, it was written on the wall.
Absolutely.
But for present purposes, your lordship should know, the matter started on 27th, not 29th. The 27th order is important.
Right.
Because
27 is the first.
We've seen that first order.
was based on minutes.
That order gives time to reply to the disqualification notice until 12th, the 12th of July.
Which was argument Mr. Kaur and I opposed each other, was based entirely on Navam Arabia. That you cannot, no, we were all there. And nowadays there is video recording also, based on the fact that you can, otherwise the disqualification can't be stopped. The idea, what is the foundation of the whole case? The foundation of the whole case is that I have given a notice to the speaker. The speaker cannot proceed.
According to you, the speaker had to decide the disqualification
That
notices
time was
first.
extended.
That time was extended.
Therefore, he could not decide.
And by the second interim order, the floor test was directed to be
So
decided
it
on
was
the
an
12th.
injunction against the speaker. The argument legally was based only on Navam Arabia. That
rule.
you have a notice against you.
I was also there, my lord, it's incorrect, factually incorrect.
Very well, it was based
Because-
also on Navam Arabia.
1 second, no, 1 second. My lord, the
Well, what's the point?
argument was that there is a compliance with the rules which is needed been prescribed for not less than 7-day period. This is only 2 days, period for natural justice is going to be heard. So it is compliance of natural justice which was
One second,
the foundation
hold on.
for passing of the order.
That also is in violation of Kyoto.
It doesn't stop.
Read the rate. Sky.
1 second, the time
All right.
granted up to 12th.
Let's
it
not-
doesn't
All right,
stop
we'll just
speaker from-
consider. Yes,
Let me
all right.
finish quickly,
So
madam.
we are merely referring the correctness of number.
There's no point in doing all this.
Complete this, Mr. Sibbal.
Anyway, we don't have to go into the
Petition under 6, seeking disqualification, the petitioners under 2(1)A of the 10th schedule. Not to take any action on the same until the resolution for removal is decided. This is the first prayer. Now, the other prayer also was that 2 days notice has been given. That's also a prayer. But plus, that also is contrary to Kyoto. Because Kyoto says you can't interdict the proceedings till the speaker decides. And your lordship knows in Ravi Nayak, the 2 days notice was upheld by the Supreme Court. But that's the, at the moment, what has happened is official orders passed time to time. Resulted in this. And the basis of all this, Navam, is why we voted for the authoritative announcement so that.
the correctness of Nawab.
Yes.
Thank you. Anything else, Mr. Sibbal?
Just minutes, I was just pointing out what they had said, so that your lordship knows.
They will.
That's
they
what
will-
let them
they will anyway-
what we will do.
This is in defense terms a preemptive strike.
Please say what they will do.